two tasks of environmental pragmatism, according to Anthony Weston. The first task is to describe and situate natural resource values and their supporting describe and situate the web in which those natural resource values that you happen to care about are situated. Okay? In the context of the webs of other values which make them meaningful and compelling. To justify or explain a value. Okay? That's kind of what we've been after all term long, isn't it? I mean, in a way, right? That's sort of a simplistic account of what we've been doing, of our project overall. We've been trying to justify values in natural resources that many environmentalists, right, are constantly asserting. There are these values in these old growth trees, right? And we're trying to explain, okay, what is that value exactly? How do you justify this claim that the radical environmentalist is making, right? That we have an obligation to these old growth trees, for example, or to these salmon runs, right? So how do we justify this claim that we have an obligation, right? All right? And Weston says to justify or explain a value, I think he would say to justify or explain an obligation is to reveal its organic place among our other values, among our other obligations. Okay? So that's the first task, and it's just a descriptive task. Okay? It's not prescriptive, it's not normative, it's just descriptive. Okay? Second task, and this is of course very difficult. There are some really difficult and thorny conflicts that emerge around natural resource values and how we use natural resources. Okay? So the second task that an environmental pragmatist has to undertake is the task of adjudicating conflicts between natural resource values and other sorts of values. When values become problematic, when choice is required, then they need articulation and defense, but to call them intrinsic, in Ralston's sense, now offers no help. Since we have to disconnect objects and actions from their context in order to value them just for what they are in themselves, what they are in relation to everything else is pushed out of focus. What Ralston's defense of the notion of intrinsic values may finally illustrate is the way in which the project of grounding natural values finally cuts itself off from the real life task of assessment and choice. For assessment and choice, we must learn again to relate values. So, this essay, Between Means and Ends, is mostly a critique of the concept of intrinsic value. Okay? And we should remember that intrinsic value, the emphasis on the intrinsic value of nature historically has gone hand in hand with an emphasis on wilderness preservation. Okay? All right, the whole turn away from Pinchoian conservationism, for example, exemplified in Aldo Leopold's work, is usually understood as a turn toward the claim that non-human natural entities have intrinsic value, not merely instrumental value. And we could also interpret Christopher Stone's defense of the legal rights of non-human natural entities. Also, and is very commonly interpreted, right? His defense of the legal standing of forests is commonly interpreted as being based on the notion that, forests have intrinsic value, right? So this notion of intrinsic value is true. Historically, it's done a lot of work, all right? The movement to preserve wilderness, as exemplified in the Wilderness Act of 1964, is also usually defended in terms of the intrinsic value of wilderness. Wilderness in that act is defined as places in nature that are untrammeled by man. That's the language, untrammeled by man. Right? So out there, it's always interesting to me to think of what happened at Celilo Falls, and if there was any place that qualifies as a pretty place that environmentalists and conservationists care a lot about. I mean, it's up there with the Grand Canyon, right, and Yosemite Falls and Yosemite Valley. From what I've read about it, obviously I'm too young, I was never there, right? But from what I've read and from some of the footage I've seen, I can see how non-indigenous people, obviously indigenous people, it's in their heart, that's just about as deep as you can go in their culture, right? And it's almost that the sense in which they valued Celilo Falls, there's a sense in which a non-indigenous person is not really capable of even understanding that. You have to be part of their culture, right? And they won't really talk about it, right? It's too deep of a loss. But right around the same time that Celilo Falls was being destroyed. Celilo Falls is on the Columbia, right? It's up there by the Dalles. The Dalles Dam flooded Celilo Falls in 1957. But right around the same time, 2 years before, environmentalists had won this great victory in Utah, of all places, northeastern Utah. This remote place called Dinosaur National Monument was threatened with 2 dams that the Bureau of Reclamation wanted to build as part of an Upper Colorado River storage project. And David Brower, the executive director of the Sierra Club, and some other activists. This all happened around in the early 1950s, right? And this whole time, the Army Corps of Engineers was busy building the Dalles Dam, right, and getting ready to inundate Celilo Falls. Meanwhile, the Bureau of Reclamation was threatening to inundate this beautiful place, but it's way out, in the middle of nowhere, right? But environmentalists would like to go river rafting there. Anyway, they organized and they got Congress to stop it, right? And they saved Dinosaur National Monument. They stopped those 2 dams from being built. Although the compromise was, some of you know this probably, the compromise suggested by David Brower himself, executive director of the Sierra Club, his biggest mistake, the biggest regret of his life, was suggesting that compromise, Glen Canyon Dam. Right? And sure enough, that's what they ended up building. Instead of those 2 dams that would have flooded Dinosaur, they built Glen Canyon Dam, which flooded Glen Canyon, all these beautiful slot canyons in the Colorado. Anyway, but it's just interesting to notice that these 2 projects were going on at the same time. And environmentalists put a stop to one of them, right? On the basis of a lot of this wilderness preservation kind of thinking, right? Intrinsic value kind of thinking. But when it came to Celilo Falls, because Celilo Falls is right here, right? It's right on the Columbia, it's right near urban areas, right? It's not out there, it's not remote, it's not a wilderness. And it was heavily used by humans for at least 13,000 years, right? Heavily used by fishermen, by fishing communities, right? So it's not eligible the way that Dinosaur National Monument was eligible, right? For protection. Somehow, right? Philosophically. And instead, it was destroyed. And of course, some of that is racism, too. A lot of it is racism. But, it's a pretty amazing story. We'll try to get to some treaty fishing rights stuff today. All right. So environmental pragmatists say, look, we should just stop emphasizing wilderness protection. We should stop emphasizing intrinsic values. Our goal is to reconnect culture and nature. Our goal is to reconnect human and the more than human world. Okay? That should be the underlying goal of whatever we do as activists, as environmental activists, and whatever we do as environmental philosophers, according to Anthony Weston. That should be our goal, right? And that sounds a lot like what Thomas Birch is saying too, right? And both of these thinkers have issues with wilderness preservation and have issues with claims to intrinsic value, right? Now, neither one of them, though, is going to say we should stop preserving wilderness. What they're both going to say, however, is that they're going to say that we should continue preserving wilderness, but we should do so as a way of reconnecting culture and nature, and not as a way of underscoring a gulf between culture and nature, right? Which is currently how things seem to be working. All right. I don't know how much more of this we should get through. I'm struggling a bit today. Just got a very busy weekend. All right, let's just get into some salmon stuff. All right, enough of this philosophy. But yeah, this is where Celilo Falls was, right up in here, right? And this is all the Columbia Gorge. And these are all the most valuable treaty fishing sites. I got a little ticked off, you know. So I heard these guys in the hallway, right upstairs here on Friday. I think I was filling my water bottle at the hydration station on the 4th floor. These guys were talking about, this one guy was talking about getting a job at Bonneville Dam. He said, yeah, I used to be in the Army, I used to be in the military, you know? And he's getting his degree in engineering, right? So anyway, I had the nerve to say, you know, they should probably just remove Bonneville Dam. And of course, they were very sarcastic. The two of them both were sarcastic. They replied very derisively and sarcastically. And good luck with that. You know, I think people need their electricity. And it was like, and laughing too. It was almost like it was such a no-brainer. The thought of removing this dam here is so stupid and so idiotic that it's not worth it. Everybody knows, right? Everybody just knows that's a stupid idea. We don't need to do any sort of analysis. We don't need to think about treaty fishing rights. We don't need to weigh the benefits of lost salmon, you know, all the lost salmon against the benefits of the dam. You know, we don't need to do any of that. It's just plain obvious, and you'd have to be an idiot and some kind of wild-eyed freak, right, to say that you ought to remove this dam. But the fact is, this dam, these two dams flooded every single one of their most valuable and most precious historic fishing sites, which are guaranteed under the language of the Stevens Treaties to be protected. They have to have access to them under these treaties, right? And so, and then the second guy, he lingered around a little longer, and he did admit, he said, well, I'm in favor of honoring our treaty rights, you know, and yet it seems to me, I don't know, man. It seems to me that if you want to honor our treaty fishing rights, right, our obligation, not our rights, our obligations. If you want to honor our obligations that our ancestors signed into a treaty, then you have to remove this dam and you have to remove at least lower them all dramatically. Because all of these usual and accustomed fishing sites, which are protected under the treaties, are under 50 feet of water, right? So, by definition, you can't have access to a site that's under 50 feet of water, right? So it's just, duh, you know, and all these dams are violations of these treaties, believe it or not, that nobody ever talks about, hardly anybody's ever even heard of. All right, the Stevens Treaties, this guy, Isaac Stevens, who later went on to fight in the Civil War, actually, and died a glorious death, fighting on behalf of the Union Army against the Confederate rebels. But before he was in the Civil War, he was the territorial governor of Washington Territory. You know, Oregon became a state in 1859, on Valentine's Day of 1859, but Washington did not become a state until 1889. So for a long time, it was just a territory, and this guy was the governor during the early 1850s, and he also was appointed by President Pierce, okay? President Pierce sat him down and said, you know, Governor Stevens, we really need you to go around and see if you can extinguish title, or extinguish use and occupancy rights among all the Indians that live out there. Because we want to clear it, we want to be able to give this land to our citizens, and we can't do so free and clear until we negotiate some settlements with these wild Indians, right? So he had to go all over the Northwest, right, in a treaty party, about 15 men riding around on horses, right? They went all over, all the way to Walla Walla, all the way out to Idaho, and then all the way up to Puget Sound. And anyway, they went all over the Northwest, and they negotiated treaties with a whole bunch of different Indian tribes, okay? And they ended up signing 9 treaties with 23 tribes and confederations. The 4 that we're concerned about here are our local treaty tribes, Yakima, Nez Perce, Umatilla, and Warm Springs. They're all located in the upper Columbia. Their usual and accustomed fishing sites are all pretty much from here up to here, okay? The other group, the other very significant group of tribes that Governor Stevens negotiated settlements and signed treaties with are all up in here, okay? So there are 2 different treaty areas. There's the Puget Sound Treaty area, and then there's the Mid-Columbia Treaty area, okay? And Salilo Falls was actually almost the borderline between the tribes that down here was all Chinookan, and the Chinookan territory, and the Chinooks never signed any treaties. But these guys all signed treaties, and so anyway, their usual and custom fishing sites are all, you know, up in here, okay? And we're not going to concern ourselves with these guys, but these sites up here were much more valuable because their salmon runs are doing much better than ours. So, but this is what they ceded, 64 million acres, all right? So those benefits that they received were in exchange for use and occupancy rights to all of these. a whole bunch of land, right? 64 million acres, where they roam free, right? And that's what they gave up. Governor Stevens was told by President Pierce that he had to prepare Northwest lands for Euro-American settlement by lawfully terminating. All right, that was our goal, the U.S. government's goal, its goal. All right, pointed out here that that the Supreme Court had already settled question about Native American title to their lands, and European governments and North American, colonial European governments have always asserted that title came with European sovereign. Okay, so there was no title to the land. I don't think I brought an attendance sheet today, Andrew. Is that what you're worried about?
No. I was going to ask, was that the Supreme Court decision that President Jackson basically said that like he made the law and now let him enforce it, and then? Yes,
that's right. That's right. Although there was a series, there was a 3 decisions known as the Marshall Trilogy, named after Chief Justice John Marshall, who was Chief Justice for a long time. Anyway, he's the guy that kind of formulated legal doctrine in the United States regarding indigenous people. Anyway, the theory has been all along, it's kind of an offensive theory, really. But the theory is that title only comes with the sovereign, with the European peoples, because the indigenous people of North America, Africa, Australia, all these new lands, right, South America, Central America, the theory was that they didn't mix their labor with the land, okay? They occupied, they used it, but they didn't mix their labor with it enough to give them title, right? It's all rooted in John Locke's theory of property, right? According to John Locke's theory of property, this is another Enlightenment thinker, right? Anyway, it had very, very important practical repercussions, because it led to the idea that indigenous people, because they don't, which was wrong, by the way, they did mix their labor with the land a lot. They did a lot of things, and actually what they did at Celilo Falls is so obvious that they mixed their labor with the land. And they actually owned those sites too. Those sites would be passed down from generation to generation and kept within a family. So they had ownership, right? I mean, there were a lot of empirical mistakes about how they lived their lives that fed into this idea that they did not, and could not have title to their land. They did not own their land. And that's why non-native people could come and take it, right? And the non-native people brought title with them, right? So that wasn't the issue. What was the issue is that, sure, they didn't have title, but they did have use and occupancy rights. And so that's what we need to extinguish. We need to make sure those are gone. Put them up on these little tiny reservations, right? They can have use and occupancy rights to that, but all the other places where they went before, we want to make sure that's all free and clear, so when American citizens settle there, they won't be encumbered, all right? So their job was to terminate these encumbrances, right? And that's what they did, right? And then the tribes, meanwhile, they had their own ideas, right? They had their own interests, their own perspective. And they knew that these European people were coming in wave after wave after wave. And they had sent emissaries. People from their people had gone to the East Coast. And they had visited, right? They rode the train all the way to Washington, D.C. and New York. And they saw how big these cities were, and they saw that there were more ships with more European people coming all the time. And so they came back home and they said, we don't have any chance against these people. There's no way we can defeat them. They're going to come. And so we have to try to protect what we can. And so they had very limited goals, right? But what they wanted, they really, really wanted, was really important to them, to preserve their fishing culture and their fishing economy, okay? They wanted control over remnants of theirs, so they wanted some homelands, small little reservations, but mostly they wanted to be able to continue fishing without being molested by the cops or by anybody at all those places where they were used to going fishing, okay? All of their traditional fishing sites outside of, right, off reservation, we're talking about everywhere where they used to fish, they wanted to continue fishing there, okay? And they wanted to continue earning a moderate living. That's the language used by the court. The court uses the language moderate living standard. And this has all been recognized by U.S. federal courts. This is what these are the goals that the tribes set forth to achieve when they sent their negotiators out to negotiate the Stevens Treaties. All right? And so the tribe's main tool in securing what they wanted was this language, the fishing clause. Okay, the fishing clause, it's not exactly the same, but all 9 Stevens treaties contain this language. Okay? The right of taking fish at all usual and accustomed stations is further reserved to said Indians in common with all citizens of the territory. Okay? So that's what was written down in the piece of paper, right? And now it's up to the courts. You know, in the 60s and 70s, the courts had to figure out what this language meant. Okay? So anyway, how did the indigenous fishers get to court? Well, they had fish-ins, and they invited journalists and people with television crews, and they'd get arrested. They'd go fishing, right? These native indigenous fishermen would go fishing like they always did every year, and then cops, state cops, right? State Fish and Game Enforcement officers from Washington and from Oregon would come and arrest them and say, they'd say, where is your fishing license? You're fishing off season, you're not supposed to be here, and they'd arrest them, right? And then they'd hire, and they'd get a lawyer, right? And it was all set up, right? And then they'd appeal, and they ended up winning, right? They'd go to jail for a while, but then their lawyers would win. Anyway, and so step by step, they asserted and were recognized in court these various rights that they had, guaranteed under the treaties, right? So, specifically, they asserted 3 different. This is the most litigated clause. That one little clause right there, the most litigated clause in the history of indigenous treaty litigation. Right? It's gone 7 times in front of the U.S. Supreme Court. Of course, dozens of times, maybe hundreds of times. The various terms. The treaty has been litigated in the lower federal courts. All right, and it's long been accepted that tribe members are exempt from. The states cannot regulate treaty fishers, right? Their relationship is with the federal government. And the states have nothing to say about what they're doing. All right, states can't interfere with tribal fishing. And federal courts have upheld treaty tribes' access to off-reservation traditional fishing sites. Okay, they've asserted access rights. The courts agreed with them. Property owners can't stop them from going on fishing where they always fish. Right. Second, and even more important, federal courts have upheld their claim that they have a right up to 50%, and that's the law of the land. Right. That's how that language "in common with." Right. That was the last really thorny language. What does that mean? What does that mean? And the courts had to figure out what that meant, right? And in the end, the court said what that means is that treaty fishers have a right to up to 50% of harvestable fish, and then non-treaty fishers, get the other 50%. All right. So 3 kinds of rights asserted by the tribes. All right. Simple rights of access. Before they were being blocked off. I mean, literally, physically, they couldn't get to where they had to go to do their fishing, right? A lot of times by fish wheels. Fish wheels would block them from going to where they, anyway. So they asserted rights of access, they asserted rights of allocation. Okay, access rights, allocation rights, and then most important of all, and these rights have not, this is just still hanging out there. This is the big, huge, rights to healthy fishery habitats. If the tribes are correct and the Stevens Treaties protect their rights to healthy fishery habitats, that would be great from an environmentalist point of view, right? Because all those dams, not to mention all kinds of other things that we've done to our rivers, have harmed fishery habitats. And so if the tribes are correct and their rights to healthy fishery habitats are protected in those Stevens Treaties, then they would have a strong case that the 4 lower snake dams and many of the other dams in the Columbia River, because they slow the waterway down, right? They dramatically and adversely affect fishery habitats. But as you'll see soon enough, I got to kind of go racing through the rest of this material. These 2 sets of rights have long been upheld, and treaty fishers have won every single case that, related to these kinds of rights. this kind of right, this last set of rights, courts remain undecided whether or not the treaties impliedly reserve. The tribe's argument, and the courts have agreed on these two, is that these are implied. These rights are implied in the language of the treaties, right? They're not explicit. It doesn't say explicitly, right? But it's implied. According. All right. Okay, and these three sets of rights, according to the tribes, are taken as essential, are understood to be essential and necessary for achieving their primary overriding objective in negotiating the treaties. Okay? Preservation of traditional fishing-based cultures, economies, and livelihoods. All right? So these are three cases that went to the Supreme Court, which established tribal access to fishing sites. Okay? For those of you that are interested, I think I have a long excerpt from Winans up here. Yeah. There's a fish wheel. These first two cases actually, these two cases both involved fish wheels. The Winans brothers and the Seufert brothers were both salmon barons who operated. The Winans family and the Seufert family both operated massive salmon cannery facilities on the Columbia River. And they would operate these fish wheels. And they look like that. See, there are a couple of humans standing there. These fish wheels, they kind of look like giant Ferris wheels or calliopes. And the part of them, the bottom of the fish wheel is in the current, right? And I can't tell. It looks like the current's flowing this way in this photograph. So that wheel is being spun like this, right? Okay, with the current. And which way are the salmon? Which way are the salmon swimming?
Downstream.
They're swimming upstream, right? The big June hogs are swimming upstream, right? And so there are buckets. There are all kinds of metal nets on here. And every time that wheel goes underwater, right? And they always locate. They place these fish wheels. They build and install these fish wheels at a place in the river where they know that the salmon have to go because of the currents, right? And how would they identify these places? Well, they would watch the Indians. The Indians always knew where the fish had to go. And so then they would boot the Indians off, right? They'd send out men with guns and clubs and just beat the crap out of them. And then they'd build a big fish wheel right there. And then the Indians would say, well, wait a minute, we have treaty fishing rights, you're not supposed to do that. And they'd hire an attorney, because they were more peaceful, right? They wanted to do things peacefully, so they'd hire an attorney. And then go through court. 5 years later, finally they'd hear, hey, we won, right? And then the fish wheel would have to be removed. But meanwhile, these fish wheels were rapacious and predatory and indiscriminate. They caught everything. And I think one fish wheel is just phenomenal. You guys wouldn't believe. You guys don't believe half of the empirical things I tell you. So what the hell? 72,000 pounds in one day of salmon. One fish wheel. That was a record. One fish wheel. I think it was Seufert's wheel number 5. I forget exactly where it was placed, but in one day it caught 72,000 pounds of salmon.
Take them out of the river? Was that the intent?
Oh yeah, look how they're built. See, it's so very efficient, right? You don't need a power source. The river is your power. It runs on the current of the river. And the fish get caught in the bucket. They come up here. They drop out of the bucket onto a belt, and then the belt takes it off to the truck. And the salmon buyers are waiting there by the belt. Here's your money. Let me have all those salmon, and they go off to the cannery, and boom, just like that.
That's insane.
It is insane. The mechanical canning device was, I think, invented in about 1875 or 1876, and at that point, the harvest accelerated dramatically because it made it possible for them to package their product much faster. Before, they had to use human labor to do all that. Mostly Chinese people, interestingly enough, worked in those canneries. But once they developed that canning technology, boom, mechanical. They always had canning technology, but they had to do it manually, right? Napoleon, actually, to feed his army, developed canning. Yes, Andrew.
How much did the salmon populations decrease once the fish wheels were implemented?
Well, it's just unbelievable, how abundant they were before. Every method of harvest you could imagine. I mean, they would, on the lower river, they used teams of horses to pull giant, mile-long nets on the shore, right? They'd use teams of 20 or 30 horses, and anyway, there are stories that would just break your heart of how abundant these fish were. Anyway, this is nice language in USD Winans. How much more do I want to get through here? I want to get through as far as I can go, so I'm going to skip the language in Winans, but there's some really beautiful language in there in that decision. It's all quoted right here, USD Winans. This is 1905. And in case you're wondering, well, how is a usual and a custom site identified? It's just a question of fact for the finder of fact. If it goes to court and there's a trial on the issue, then the tribes will present expert testimony. They'll bring up some tribal elders. They might even bring up some anthropologists, and they'll testify. They'll say, yep, around treaty time, they would go fishing there all the time. And then, boom, the judge would say, okay, that's it. You got your site. You can't be harassed, right? All right, allocation, the second set of rights, okay? Access has now been guaranteed, and now in the 1960s and 1970s, they start asserting their allocation rights, okay? And the two main cases here are US v. Oregon, also known as So Happy versus Smith, and US v. Washington, phase 1. And here the issue is whether or not the treaties require that the tribes be guaranteed a certain share of harvestable fish. Remember that language, in common with, all right? It seems to guarantee a certain share of harvestable fish. Now the question is exactly what is that share? What allocation is impliedly reserved to the tribes in the treaty? All right. First, in US v. Oregon, district court judge in Oregon said, well, it means a fair share. Okay. He didn't quite want to specify. Right. Next up, next to bat, George Bolt. Okay. Fair share. All right. We got to get a little more specific, folks. What does that mean? Fair share in common with? It means 50%. All right. And that, with one fell swoop, Judge Bolt became the arch enemy and the hated enemy number 1 of all non-Indian fishermen in the Pacific Northwest. Judge Bolt, and they hated him with a passion. And but because he ruled, right? And up there in Puget Sound, this is a very valuable resource. As we know, most of our salmon here, especially by the time you get to the mid-Columbia, right, where the usual and accustomed fishing sites of the 4 treaty tribes, Umatilla, Nez Perce, Yakima, and Warm Springs, right? There aren't a lot of fish to fight over, right? There just aren't. We used to have the greatest salmon stream in the world, right? And now it's kind of sad, right? There's not much left. But in Puget Sound area, there's still a lot of salmon left to fight over. And so those fishermen up there were very furious, just absolutely furious with Judge Bolt. But he just took out his dictionary, right? And he said, in common with means sharing equally, and sharing equally means 50%, right? So he concluded that treaty fishers have a right to up to 50% of salmon destined to pass the traditional fishing sites of treaty tribes. This is a tremendous transfer of wealth. You need to keep, and that's why so many fishermen were furious, because their wealth was taken away from them and given to this group of people who were less than 1/10 of 1% of the overall population of the state of Washington. Just tiny, tiny, tiny little group of people, right? And they get all these fish, right? It seems unfair, but that's what they bargained for. That's why they signed those treaties. So in the end,